MSW Media.
The rule of law is not just some lawyer's turn of phrase. It is the very foundation of our democracy. The essence of the rule of law is that like cases are treated alike. That there not be one rule for Democrats and another for Republicans, one rule for the powerful, another for the powerless, one rule for the rich and another for the poor, or different rules depending upon one's race or ethnicity. To serve as Attorney General at this critical time is a calling I am honored and eager to answer.
So now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Welcome to episode 196 of Clean Up on Aisle 45. It's Wednesday, October 23rd. Oh my gosh, we're so close, less than 2 weeks away from the election. I'm Allison Gill.
Hey, Allison. Yeah, this is the penultimate episode before the election. I'm Pete Strzok, and we have a packed show today, including rulings against the Trump allies on the Georgia State Board of Elections, as well as Trump's appeal to the Second Circuit to move his 34 felony count case to federal court.
No, I don't think it's going to work. But we also have an update on Jim Jordan's indicted witness, Alexander Smirnov. We have leaked documents that show U.S. intelligence on Israel's plans to attack Iran, and some more bad news for Rudy Giuliani in Arizona, which we always love sharing with you. But first, we have some new patrons to thank, including Make This Fucking Episode of The Twilight Zone End. Very well put. Teresa Seidel, Dawn Donaldson, Susan Ryan, Dan, and Susan Scott. Thank you all so much for signing up to be patrons of Clean Up on Aisle 45. If you want to sign up and get these episodes ad-free and early, plus the second bonus episode every week, you can do that by going to patreon.com/aisle45pod, AISLE 45POD. Pete, where should we start today?
Well, you know what? I think it's only fitting we start in Georgia, where, by the way, voters have broken early voting records despite the Georgia State Election Board's best efforts to curtail the vote counting process and pretty brutal voter suppression laws. Now, and this makes my blood boil, just like every other attempt to disenfranchise and make harder to vote, the kind of fundamental basic tenet of our system of government, the whole democracy, the whole word itself. But God forbid we have an entire political party trying to make it hard to do that. But in recent weeks, voting rights advocates have sued to stop the Georgia State Election Board from enacting new rules voted on by a 3-2 majority. Guess what? All three of the Republicans on that board are election deniers and Trump allies, and all of their rules have been rejected. Well, so let's go over them. Now, this is a ruling from Judge Thomas Cox back on October 16th, who wrote, in September 2024, the State Election Board promulgated a number of rules challenged by the plaintiffs. For the reasons set forth below, the court finds 1, plaintiffs have standing to assert the claims in their complaint and amended complaint. 2, SEB, that's the State Election Board, SEB rules are unsupported by any provision of Georgia's election code and are, in fact, contrary to the election code. 3, the SEB lacks authority to promulgate these challenged rules. 4, the SEB has no constitutional authority to promulgate these rules because the General Assembly did not provide sufficient or realistic parameters guiding the SEB's rulemaking here. 5, the U.S. Constitution prohibits the SEB from enacting election rules regarding the election of federal officers. 6, declaratory relief is warranted. And 7, an injunction is warranted prohibiting the enforcement of the challenge rules and vacating the same.
Yeah, and there are 7 rules here, by the way, that Judge Cox addressed, because there were some separate cases going on, and Judge McBurney had consolidated them all and previously put a stay on all of these rules pending the outcome of what this judge had to say. And let's talk about those 7 rules. I could give them to you, like the numbers, the SEB numbers, but I'm just going to describe them. The first rule would have allowed county board members to conduct a reasonable inquiry of election results, an undefined power they previously never had, and was the purview of the courts. Now, the judge says, this rule adds an additional and undefined step into the certification process. As such, it is inconsistent with and unsupported by Georgia election law and is thus void and unenforceable.
Yeah. Now, the second rule passed by the SEB that the judge addresses is the so-called examination rule, granting county board members access to all election-related documentation. The judge says the SEB rule creates a statutorily unbounded scope under which superintendents can consider unauthorized materials when tabulating, canvassing, and certifying election results. Thus, this provision is void, as it is inconsistent with the statutory framework, void, and unenforceable.
Nice. And the third rule passed by the SEB is the signature and photo ID requirements on absentee ballots when they are delivered. To this, the judge says, Georgia law provides that absentee ballots may be mailed or hand-delivered by a voter's mother, father, grandparent, aunt, uncle, brother, sister, spouse, son, daughter, niece, nephew, grandchild, son-in-law, daughter-in-law, mother-in-law, father-in-law, and brother-in-law, sister-in-law, or any individual residing in the household of such elector. Additionally, this provision allows any caregiver of any disabled elector to mail or deliver that ballot. Neither statute requires presentment of a signature or a photo ID by the authorized person delivering the ballot. The SEB thus has no authority to require such presentment as a condition of accepting and counting an otherwise properly delivered ballot.
Fourth rule mandates video surveillance and recording of drop boxes after polls have closed. The judge says the SEB cannot, by rule, require something the General Assembly both did not legislate and specifically considered and declined to enact. Thus, this rule is unsupported by and contrary to Georgia law and is unenforceable and void.
Now, the fifth rule expanded poll watching areas. And the judge here says, the election code requires designated poll watchers at the check-in area, the computer room, the duplication area, and such other areas as the superintendent may deem necessary. But the SEB expanded these mandatory locations to include areas that tabulation processes are taking place, including but not limited to provisional ballot adjudication of ballots, closing of advanced voting equipment, verification and processing of mail-in ballots, memory card transferring, regional or satellite check-in centers. Now, this is contrary to and exceeds the limited mandatory poll watching areas promulgated by the General Assembly, and therefore this rule is inconsistent with the statutory framework and void.
I'm sensing a trend. I think we may get a clean sweep, but let's keep going. The sixth rule imposes additional reporting requirements for absentee voting. The judge says the election code requires business daily reporting rather than weekend reporting as added by the SEB regulation. The election code also does not require reporting by partisan and nonpartisan votes, while the SEB regulation does. And the election code requires posting certain information in a place of public prominence. But the rule requires information to be posted in a place accessible 24 hours a day to the public. This rule impermissibly expands upon and contradicts what is outlined in the election code. Thus, this provision is void, and it is inconsistent with the statutory framework.
And the seventh rule was the hand counting of ballots at the precinct level, right? Not to count who voted for who, but just the number of ballots. And the judge says, this rule requires poll managers and poll officers to engage in a cumbersome process of ballot hand counting after the close of polls on Election Day and prior to transmitting the ballots to the superintendents for certification. This hand counting exercise is nowhere authorized by the General Assembly and the Election Code. In fact, the rule vastly expands the authority and obligations of poll officials in preparing ballots pre-delivery to the superintendents and pre-certification. Georgia law proscribes the duties of poll officers after the polls close. Hand counting is not among them. Thus, this rule is void and inconsistent with the statutory framework.
Womp womp. And so the judge concludes with this. Because this court has determined that these 7 SEB rules are contrary to the laws of the state of Georgia, the Constitution of the state of Georgia, and the Constitution of the United States, and that the SEB had no authority to implement these rules, the court here declares that these rules are illegal, unconstitutional, and void. The court hereby enjoins the state of Georgia and the SEB from enforcing, requiring compliance with, or otherwise utilizing these SEB rules. Additionally, the state and the SEB are hereby directed to immediately remove these rules from their rolls and official reporting, and to immediately inform all state and local election officials that these rules are void and are not to be followed through the same mechanisms that the SEB provided such rules to the state or local election officials, or through the same mechanisms that they informed the state or local election officials of these results. Again, like so many things, it's the perfect Gene Wilder, Willy Wonka moment of you get nothing.
We're all stupider for having read these rules. I award you no points, and may God have mercy on your soul. And the thing here, the thing I like the best is, like, not only are these rules unenforceable, but you, SEB, all of the ways that you told poll workers that they had to follow these new rules, whether it was email or a website or posting them on paper and mailing them, you have to use those same avenues to inform them that your rules are unenforceable. And further, you have to direct them not to use any of these rules. And you have to do that, like I said, through the same channels you initially told them that they had to. So I love that for them because they're going to be real busy. I think they've created a bunch of extra work for themselves by trying to pass these unenforceable rules. And, the Republicans have said they're going to appeal. But I really don't think that there's any chance that either these appeals will be heard, or that even if they want to hear them, that there'll be time to overturn this injunction prior to the election. But we will keep you posted on that. I don't know.
Yeah, and what's so aggravating, and I know, we chuckle or I made the joke about Willy Wonka, but what's so aggravating about this is you would think by all this new rulemaking and all this litigation that there must be some sort of problem or history of voter fraud. But the reality is what is so just hypocritical and cynical and just disgusting in the extreme. There is no history of mass voting irregularities. There was not in 2020. There wasn't in 2016. There weren't in the midterms. All of these lawsuits claiming that there was failed. If anything, the few instances that they found were actual Republican voters, including down in the villages in Florida, and obviously not Georgia, trying to vote for Trump twice. In Pennsylvania, Trump voters trying to vote for, a dead spouse. But the fact of the matter is, across the entirety of the United States, the issue of voting fraud is a negligible one. There are all kinds of other election violations, but the idea that people are going in casting extra ballots just isn't a problem. It hasn't been a problem since slave owners and their descendants tried to disenfranchise minorities, for the most part, after the constitutional amendments, which you won't find anywhere in the Trump Bible because we stop at 10, because we don't need those pesky additional amendments giving, the right to vote to women and to black people and other minorities. Don't worry about those. Keep those out of the Trump Bible. Don't need them. Mm-hmm. And the fact of the matter is, this is a disgusting continuation of that same disenfranchisement behavior, making people, unable to vote, making people afraid to vote, saying we're going to, beef up, observation. We're going to have like folks in lawn chairs with weapons watching drop boxes and polling places, because you know what that tends to do? That tends to intimidate minorities. That tends to intimidate people who aren't, the white Republican, prior majorities. And this is what all of this is. There's not a history in Georgia of voting fraud. There isn't. Mm-hmm. There's none. It does not exist.
Nowhere, but actually. And they're trying to, their latest gig is that, they're removing voters from the rolls because there could be non-citizens voting. And DOJ stepped in multiple states and sued to stop that, because they noticed that of like the 3,600 voters flagged for removal, 2,200 of them were actual, eligible voters. So they have like a 65% error rate on removing these voters from the rolls. So it's, it's clearly targeted at specific precincts and certain voting communities. And it's probably not going to stop anytime soon, which is why I'm so glad that the Harris campaign and it was the Biden campaign before, but they had doubled the number of campaign lawyers working for their campaign. And then, we have, of course, Mark Elias, who's got 190-something cases going in 30-something states, to try to make sure people have access to the box. I think I shared one of his, posts about Democracy Docket, and I said, voting is the freedom that unlocks all other freedoms. And Mark Elias unlocks voting. So, we have to make sure that we stay informed about these voter laws. And there are hotlines you can call if you've got a problem voting. And you can always request a provisional ballot whenever you show up and they say that maybe you're not on the rolls. But, you can always check vote.org to make sure that your registration is cool and good to go. I've already sent my ballot in. I got confirmation from the registrar that they've received and counted my ballot. So I'm good to go. But, make sure you check in the state where you are living and where you are registered, that you're able to vote. And then, of course, we got Republicans trying to block the overseas vote, trying to literally stop military stationed overseas from voting.
Crazy.
And it never ends. And I don't think it's ever going to end. And I hope there are people out there gearing up, getting ready to go to law school so that they can become voting rights lawyers, because we're going to need a ton of them in the future going forward. It's just the new way of the world, I think. Yeah,
I can't, again, it's unfathomable that anybody as part of a democracy would seek to make it harder to vote. I mean, look at like many Western democracies, they'll vote on the weekends or give people the day off to make it easier to go vote. But not in the United States, by God. Let's do everything, at least one party, everything in our power to make it harder. And again, overseas voting, by far and away, the huge chunk of that is members of the military. And so what does it say that, you're trying to cut that back? I mean, one, it falls completely in line with, this idea of, Trump's derisive view of the military as suckers and losers. And I assume by trying to make it hard, that he assumes that the majority of these overseas military votes are not going to go for the Republican ticket, which is interesting, because I wasn't sure how that demographic would break out. But it's just disgusting, Go serve your country. Go overseas. Put yourself on the tip of the spear, wherever, on the ground, on the air, in the sea, wherever you
fighting
are.
to preserve democracy, but we're not going to give you a say in it.
No, we're not. Yes. Can't vote. Can't. Want to make it hard for those mail-in votes. It's just disgusting. Disgusting. Agreed.
100%. And we're going to have a lot more to go over in this show. We have a lot of news, and we're going to talk about our good old friend Alexander Smirnov, but we have to take a quick break. So stick around. We'll be right back.
Hey, welcome back. Let's thank some more new patrons, including Peg Pigeon, Keith Kunkel, Dimmer Beach, Linda, Kimber Cole, and Stephen A. Kaufman. Thank all of you so much for your support. Thank you for, in this critical time, as we charge into the elections, as literally the state of our nation, the stake of our democracy is never been more under threat. Thank you for your support and being part of the team and allowing us to put this out.
Yeah, and when he loses, we're going to be reporting on all of the state
the trials.
He's going to be sentenced.
Years and years of appeals up to the Supreme Court. Right?
Yeah. Yep. I mean, he's going to be sentenced in New York shortly after the election. So thank you for supporting all of that work.
Yes, indeed. So you mentioned Allison Smirnov. Let's talk about some new court filings in the Smirnov case. Now, you may remember Smirnov was arrested in February on charges accusing him of falsely telling his FBI handler that executives from the Ukrainian energy company Burisma had paid President Biden and Hunter Biden $5 million each around 2015. And the claim became central to the Republican impeachment inquiry of President Biden in Congress. U.S. District Judge Otis Wright II in Los Angeles in February ordered Smirnov to remain jailed while he awaits trial, reversing a different judge's ruling releasing him on GPS monitoring. Smirnov was rearrested at his lawyer's office in Las Vegas 2 days after the magistrate judge released him from custody. Well, Smirnov filed motions to delay his trial, and the government opposed. This is from the ruling. The court has read and considered defendant's ex parte motion for 1, continuance of trial date, and 2, findings of excludable time periods pursuant to the Speedy Trial Act, which defendant filed on September 26, 2024. The court has also considered the government's opposition. The court hereby finds that the ex parte motion demonstrates facts that support a continuance of the trial date in this matter from December 3, 2024 to April 1, 2025, and provides good cause for a finding of excludable time pursuant to the Speedy Trial Act.
Now, it goes on to say, the court finds that 1, the ends of justice served by a continuance outweigh the best interest of the public and the defendant in a speedy trial. 2, failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. And 3, failure to grant the continuance would unreasonably deny the defendant continuity of counsel and would deny the defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Additionally, and for the reasons stated in the ex parte motion, the court finds that certain periods of time should be excluded pertaining to the transfer of this case and the transport of the defendant to the district, as well as the specific factual circumstances presented by the case. But then, Pete, it says at the bottom, no good cause shown. The court denies the request to continue the trial. It is so ordered. And then also in the signature block, it said denied on this date, signed Judge Wright. And then up at the top, it says denied. And even in the title, it says denial of petition, or motion.
Order denying request. Yeah.
Order denying request. So it says denied, 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 denied all over this thing. But the body that we just read to you sounds like the court's approving it. And here's what I think happened. I think that, when Smirnov and his lawyers submitted this motion to continue the trial, to delay the trial, usually what happens in these court cases is you submit a mock-up of the order you would like the court to give, right? You say, here's our proposed order. And I think what happened is the judge copied and pasted Smirnov's proposed order in the body of this, but then denied it at the top and the bottom and the signature and the title and and at the order at the bottom without editing. Usually the judge would edit the proposed order or used the government's proposed order. So maybe they copied and pasted Smirnov's proposed order instead of the government's proposed order in opposition. And so I honestly think that the court has denied the delay of this trial to April, and I think it's supposed to continue to go on December 3rd.
Yeah, that's right. I mean, I agree with you. Both parties will include proposed orders, kind of to make it easier for the court. And typically a clerk, the judge may or may not do it. Frequently a clerk will do it. My suspicion is that, who knows what happened, and I expect this will get clarified soon enough. But I would imagine that, somebody took the wrong example for the kind of guts, and that the judge, when he went to sign it, took a look, said, okay, yeah, I see denied, and denied right above my signature, fine, didn't really read the sort of like guts of the argument. So if I had to guess, the judge intends and wanted to deny this and just that there was some sort of editing error. But who knows? We'll, again, it's a good catch that it clearly is not consistent between what's being ordered and the argument in the middle of it. So,
I'll go back on the docket and see if there's a nunc pro tunc or some sort of correction. I haven't revisited this docket on Pacer, but I'll do that, and we'll talk about it on the bonus episode, because it's just like denied all over this document. But then the middle guts is like, oh yeah, it sounds like it was written by Smirnov's lawyer. So I really think this is denied, and I think this trial is still set to go in December. But I'll verify that. Interesting mistake. I don't think anybody else caught this except for me, because I was going through writing the episode today. I'm like, this looks weird, and I went and I looked at everybody on Twitter, and everyone on Twitter is like, oh, they've moved his trial to April. But I don't think they did. But I'll verify, and we'll get back. I've put the question to legal Twitter. A lot of folks seem to agree that it looks like they copied and pasted Smirnov's proposed order instead of the government's proposed opposition, but that it is truly denied. And again, I'll verify that and let you know. I'm sure maybe if I can reach the clerk of the court and say, hey, is this denied or no? Is the trial in April or December? Let me know, and I'll see what I get back.
Yeah, I think you're right, and we'll see soon enough. So with that, let's pivot a little bit. And this is CNN reporting that we have an intelligence leak problem. And this is from Natasha Bertrand. The U.S. is investigating a leak of highly classified U.S. intelligence about Israel's plans for retaliation against Iran, according to 3 people familiar with the matter. One of the people familiar confirmed the document's authenticity. The leak is, quote unquote, deeply concerning, a U.S. official told CNN. The documents, dated October 15 and 16, began circulating online on Friday after being posted on Telegram by an account called Middle East Spectator. They are marked top secret and have markings indicating they are meant to be seen only by the U.S. and its Five Eyes allies, which are Australia, Canada, New Zealand, and the United Kingdom. They describe preparations Israel appears to be making for a strike against Iran. One of the documents, which says it was compiled by the National Geospatial Intelligence Agency, says the plans involve Israel moving munitions around. Another document says it is sourced to the National Security Agency and outlines Israeli Air Force exercises involving air-to-surface missiles, also believed to be in preparation for a strike on Iran. CNN is not quoting directly from or showing the documents. A U.S. official said the investigation is examining who had access to the alleged Pentagon document. Any such leak would automatically trigger an investigation by the FBI, alongside the Pentagon and U.S. intelligence agencies. The FBI declined to comment.
And here's a quote from the article, Pete. It says, if it is true that Israeli tactical plans to respond to Iran's attack on October 1st have been leaked, it is a serious breach. That's Mick Mulroy, former Deputy Assistant Secretary of Defense for the Middle East and a retired CIA officer. Mulroy added that the future coordination between the U.S. and Israel could be challenged as well. Trust is a key component in the relationship, and depending on how this was leaked, that trust could be eroded. I'm sure it already kind of was, with Donald Trump leaking those Iran photos and his chat with Bibi, and not to mention that first Oval Office meeting with Lavrov and Kislyak, where he gave over some Israeli intelligence to Russia. It's not clear how the documents became public, nor whether they were hacked or deliberately leaked. The U.S. is already on high alert about Iranian hacking campaigns. U.S. intelligence agencies said in August that Iran had hacked documents belonging to Trump's campaign. You'll remember, Pete, again, major leak of U.S. intelligence last year, also strained relationships with allies and partners, including South Korea and Ukraine, after a 21-year-old Air National Guardsman posted highly classified information on his Discord channel and talked about it on YouTube and Twitch or whatever. Remember that guy?
I do, and he's in jail for a long time. Jack Teixeira. Yeah, the reality is a huge number of people have clearances and access to highly classified information like this, and frankly, I'm surprised that leaks like this don't happen more than they do, or at least that we're aware of. But for this, it's particularly, beyond the fact that, again, if you look at what's described as the NGA document that contains some imagery or intelligence derived from imagery or imaging systems. And then NSA typically deals with signals intelligence, so communications intercepts or, computer file cyber type intelligence collection. Beyond the fact that just simply disclosing the capabilities of those U.S. systems, there's also the fact that, we're using those systems against Israel, which says a bunch of things, right? One, it says that we're engaging in collection against Israel. And why is that? We don't trust Israel to tell us what they're doing. We don't trust Israel to tell us the totality of what they're doing. It shows that we have gaps in our understanding of what they're doing, and that they're not, ostensibly, despite their, the close allied relationship, there may be things that they aren't telling us. And so it in addition to the, kind of the tradecraft technical problems with this disclosure, it also creates a set of, kind of political challenges, particularly in light of the fact that the U.S. support to Israel in the current conflict, setting aside Iran, I'm talking about Gaza and southern Lebanon, which, folks could argue generated the Iranian missile attack. But there is a great deal of, disagreement within the United States about whether the U.S. is supporting Israel in the manner that they should, if there should be restrictions or not. But then you add this on top of it, and, it raises the question about well, wait a minute, if you're arguing for reducing support to Israel, the question is going to be, well, why are we, yet another reason to question why we're providing support to Israel when we don't know what they're doing and we're having to spy on them. And, on the other side of the equation of, well, how dare you spy on them? They're our closest ally. We have their support and we shouldn't be doing this at all. So it just creates a kind of a political mess on top of a tradecraft vulnerability. And I think Ken Klippenstein went and published them, and I, not a big supporter of that, but all the stuff's out there. It's out of the gate.
Yeah, I think we'll probably find out pretty soon where they originated. I think our intelligence agencies are pretty good at tracking where those documents come from and where they came from. And we might see another kind of Teixeira situation. Who knows? But definitely worried about the strain that this puts on Five Eyes and our standing in the intelligence community. It's never a good thing, never a good look. But hopefully we catch them. So, all right, we have more news that we have to get to. We're going to go to the Second Circuit Court of Appeals. That's the one over New York, a federal court over New York, about Donald Trump still trying to move his 34 felony counts to federal court out of New York State. But we have to take a quick break. So stick around. We'll be right back. Hey, everybody, welcome back. All right, we have more new patrons to thank, including Andrew Costin, Thomas Ellsbury, Shar, Tony Flanagan, and Sprout. Thank you very much for supporting independent media, for supporting Cleanup on Aisle 45. We truly appreciate you. We couldn't do it without you. And now, like I said before the break, let's turn to the Second Circuit Court of Appeals, where Donald Trump has appealed his motion to have the case removed from state court to federal court. In his 99-page appeal, 99 pages, he makes the same tired-ass arguments because he knows if he loses the election, he's going to be sentenced in November and might even get some jail time. Not sure, but it's, there's a non-zero chance. And this is his introduction. This case presents complex first impression issues relating to the Supremacy Clause, federal officer removal, appearances of impropriety, and conflicts in connection with an unprecedented and baseless prosecution of the leading candidate in the 2024 presidential election, and the ability of future presidents to serve the American people without fear of reprisal from hostile local officials. In a rushed and conclusory summary remand order issued without adversarial briefing or a required hearing, a hearing is not required, the district court ignored most of these issues based on a misapplication of the Reuter-Feldman doctrine, that's also not true, and engaged in profoundly flawed analysis with respect to the issues that it chose to address. Reversal is necessary, and removal is appropriate. The underlying proceedings arise from a politically motivated investigation by the Manhattan DA, dubbed the zombie case. He loves to throw that in wherever he can. By former Special Assistant District Attorney Mark Pomerantz, because the DA refused to abandon efforts to target President Trump until star witness, felon, and serial perjurer Michael Cohen, bolstered by other financially motivated witnesses such as Stormy Daniels, concocted the type of false and implausible story that President Trump's political opponents wanted to hear. I'd like to throw in here that they also had documentary evidence proving that you falsified business records. In 2023, the district court granted the DA's remand motion in response to Trump's initial removal notice, and based on federal defenses involving immunity and preemption. That's the first removal notice. So this is, again, not his first time at bat to try to get this taken out of the courts in New York.
No. And he goes on to say, subsequent to the remand, the DA litigated the case in New York County in a manner that directly contradicted the representations they made to the district court in connection with the first removal notice. DA did so by offering evidence of President Trump's official presidential acts during the trial, and by requiring the jury to evaluate the type of complex federal campaign finance issues that the Federal Election Campaign Act expressly preempts. No, it didn't, and that was litigated. Now, the filings continues. During the remanded proceedings, the Supreme Court issued 3 intervening opinions that support President Trump's position regarding removal, including his federal defenses. The most significant of the 3, Trump v. United States, was decided after the New York County trial. The decision established a broad presidential immunity defense to criminal prosecutions with features such as mandatory exclusion of official acts evidence that had not previously been recognized, not by the district court in 2023, not by the DA at any point, and not by the presiding judge in the New York County case, acting Justice Juan Merchan. To preserve his state law rights, President Trump filed a motion to dismiss the DA's case in New York County based on presidential immunity violations, which was not fully briefed until July 31st, 2024. That motion is still pending.
Yes, it is, because we're waiting on whether or not the New York court is going to consider those, I think, 3 pieces of evidence material. Like, would they have made a difference? Would they have caused any harm had they not been introduced? Then he inexplicably brings up his recusal motions. He says on August 13th, Justice Merchan denied a recusal motion that was based on, among other key issues, 2019 evidence, and I'm using air quotes for evidence, indicating that he previously criticized Trump's use of Twitter, which is a central issue in the presidential immunity motion. Justice Merchan also made improper political contributions in 2020 to groups opposed to President Trump and his candidacy in the 2020 election, including Stop Republicans, which described its purpose as resisting the Republican Party and Donald Trump's radical right-wing legacy. In addition, evidence emerged that a company partially owned and operated by Justice Merchan's daughter, Authentic Campaigns, received millions of dollars from political opponents of President Trump who have been soliciting donations based on the DA's prosecution of Trump in front of Justice Merchan. Now, none of that, Pete, has to do with removal to federal court, but he's throwing it in there anyhow because he thinks immunity is a federal issue. And that's also despite separate motions denied by New York courts multiple times. But he doesn't stop there. He says Justice Merchan's daughter, and by the way, they have misspelled Merchan's name 6 different ways in this filing. Justice Merchan's daughter has a long-standing relationship with Vice President Harris, President Trump's opponent in the election. She was a senior staffer for Harris's failed 2020 presidential campaign, and Harris's current presidential campaign made at least one publicly disclosed disbursement to Authentic in July when the presidential immunity motion was pending. President Trump is subject to an unlawful prior restraint regarding these issues because, following the New York County trial, despite no conceivable risk to the integrity of any remaining proceedings in that case, Justice Merchan, again misspelled, insisted on maintaining an unconstitutional gag order that restricts President Trump's First Amendment protected campaign speech and impedes his ability to respond to political attacks. No, it doesn't. Based on the DA's case from the Harris-Walz campaign, Democrats in Congress, and other political adversaries. It doesn't. Trump can say whatever he wants about any of those things. And in fact, the DA was cool with actually narrowing the gag order after the conviction.
Yeah, and again, we'll talk about this in a little bit, but the whole reason for the gag order is people tend to take Trump's statements and convert those into threats against the people Trump is talking about. The entire reason for this gag order is because people tend to engage in violence based on the things that Donald Trump says. That's the entire reason for it, period, full stop. And now the filing, though, continues. On August 29, 2024, based on the foregoing considerations, intervening Supreme Court decisions, the DA's mischaracterizations and shifting positions, judicial bias, and the apparent inadequacy of state law procedures to allow presidential immunity litigation as required by the Supreme Court, President Trump filed a new removal notice. 2 business days later, on September 3rd, the district court issued a conclusory summary remand order that misapplied binding precedent and statutory removal procedure, ignored key evidence supporting the second removal notice, and misapprehended the obligation of federal courts to provide an unbiased federal forum for fair litigation of federal defenses pursuant to the federal officer removal statute.
And this is going to be fun, because if this goes to the Supreme Court, like if Second Circuit says no, and Trump appeals to the Supreme Court, the Supreme Court might have to take it because the 11th Circuit has ruled in the Meadows case that he's no longer he's a former that federal officer thing doesn't cover former federal officers, and these guys are both former federal officers, and that conflict of opinions in different circuits could cause the Supreme Court to take this case for consideration. But that's only if the Second Circuit says yes, right? But if they say no, then there's no conflict between the Second Circuit and the 11th Circuit. You know, if the Second Circuit says, sorry, you're a former federal officer and this doesn't cover you, then they aren't in conflict and the Supreme Court wouldn't be required to take it. So, but that doesn't stop them from taking shit that they aren't required to take, as we know, because of the immunity ruling. But Trump concludes with, the district court's rulings cannot withstand scrutiny. Yes, they can. And must be reversed. No. President Trump is entitled to removal so that he can seek appropriate relief pursuant to applicable federal procedures based on the DA's violations of the presidential immunity doctrine and the FECA's preemption clause. So that's his little submission. That's just the introduction. He then goes on and provides absolutely his case law and precedent arguments lack case law and precedent, and he misinterprets it. We won't really go into the details, but it's very long and very wrong. I think that's a great new name for any Donald Trump legal filing. Very long and very wrong. Because he just gets it wrong on the law a million different ways.
Yeah, and I mean, yet another thing that bogging down our legal system again, because as we've said 1,000 times, this isn't some Maytag repairman judicial system, right? The court is not sitting there idle waiting for Trump to bring this nuisance litigation. There are all kinds of other things that are going on that in the course of having to respond to this, the DA's office, the courts, all kinds of government officials who otherwise might be going out and investigating and prosecuting crime, violent crime, white-collar crime, Medicare fraud, any number of things, they have to then turn resources to dealing with this nonsense. Nonsense paid for by NFTs and gold sneakers and steaks and Bibles and watches, goddamn watches that probably are going to turn your wrist green in 6 months and no longer work. All of this getting funded by the suckers out, the true suckers and losers, not the military, the people who are brought, under the spell of Donald Trump's snake oil sales to buy some sort of memorabilia that gets converted to legal fees to allow nonsense like this to go there. And I have no doubt, look, even if there is not a split between the circuits, I have no doubt that Trump is going to take this up to the Supreme Court. Whether or not they take it up, who knows? We'll be here talking to you either from our homes in Northern Virginia and Southern California or from our outside the United States safe haven as, to escape the squads of militia vigilante justice that are ravaging the United States following a Trump victory, God forbid. But this just never ends. Just never ends. You know what will cause it to end? If he is defeated and no longer has the same support of people willing to line up and shell out money to allow him to pay attorneys to do this nonsense.
Yep. And I think there was a reporting that his PAC owes more than it has on hand because he's paying all of his legal bills. So none of the down ballot Republicans are getting any money through the RNC because it's, being filtered through first Trump 47 and the Save America PAC so he can pay his legal bills.
Ask Leon. Leon's got money. Leon Musk. Right.
Well, of course. And, to throw $100 million at Donald Trump for Leon is a drop in the well compared to the billions that he could steal from us with immunity in the Oval Office as a cabinet member appointed by Donald Trump. All of their discussions would be considered official acts. So it's just something else we have to consider when we go to the polls. I know everybody listening to this show is already good to go, but something to keep in mind when you're talking to your friends and neighbors that if you let a criminal in the Oval Office, they're going to crime and they're not going to be able to be held accountable for it anymore. So it's very important that we elect Kamala Harris because the next president could appoint as many as 3 Supreme Court justices. And if she does, we could flip this shit around. We could get rid of the immunity ruling. We could overturn Dobbs. We could, bring back the Chevron doctrine. We could bring back affirmative action. All of these terrible things can be undone. But again, we have to vote. But you know that. I'm preaching to the choir. We have one final great little bit of news about Rudy Giuliani for you in the final block of the show. But we do have to take one last quick break. So everybody stick around. We'll be right back.
Hey, welcome back. Our final group of patrons to thank today includes Cheryl May, Trump is Going Down, Salty Soist in San Diego, Harrier the Amazing Bean, and Fred. Thank all of you so much. Thank you for being part of the team. Thank you for being patrons. Deeply, deeply appreciate your support. And our final story today as every final story featuring this person does in putting a smile on my face. Our final story today is more trouble for Rudy Giuliani. Now, this comes from Judge Bruce Cohen. And it's about Rudy's indictment. For which one, you might ask? It's about Rudy's indictment for the fraudulent elector scheme in Arizona. It's like there's a big old wheel. Like when you go to, all these different states and federal jurisdictions, spin it for Rudy, and this time it landed on Arizona. Defendant Giuliani filed a motion on August 30, 2024, seeking disclosure of grand jury selection records as part of his intended challenge to the grand jury indictment in this matter. Specifically, he postured a claim that grand jurors could have been biased or prejudiced or perhaps interested in the matter under investigation. He did not provide any allegations that would support this claim, but rather imagined a circumstance where grand jurors may have been summoned and selected based upon their purported political ideology. When pressed by this court during oral argument, counsel for defendant Giuliani acknowledged that there was no underlying factual support for the claim. Rather, he seemed to assert that since there was no information about whether political party information of grand jurors was known at the time of summoning, that lack of knowledge formed a basis to investigate whether that information was possibly available during the summoning process. In other words, he argued that he should be permitted to pursue the theory, in quotes, because it had not been demonstrated that the theory was baseless. I love this. This court was not at all persuaded by the motion or the arguments made on behalf of defendant Giuliani that would support the supposition that political affiliation played any role in grand jury selection. Yet, the court elected to seek further confirmation. And it bears noting why that was ordered.
This reminds me of, didn't he say to a state election official when asked for evidence of outcome determinative voter fraud, didn't he literally say, we don't have any evidence, just a bunch of theories? And I think that's his argument here too. We should pursue my theory because you haven't proved it baseless. That's amazing. The judge goes on, there are times in which dispelling unsupported allegations becomes crucial in maintaining public trust and institutional credibility. During those times, addressing a claim promptly and clearly is essential. Hopefully, it fosters a more informed environment, one in which fact rather than speculation is controlling. Here, despite there being no apparent factual support for a claim that political ideation was part of grand jury selection, this court directed the state to confirm what was a seemingly unassailable belief. That being, grand jurors, or jurors as a whole, are not selected based upon affiliation or ideation other than perhaps their common affinity to constitutional principles. To confirm this, the state was tasked with securing an affidavit from a representative of the jury commissioner, who would have personal knowledge as to whether defendant Giuliani's concern about political party affiliation information was part of the grand jury selection process. On October 16th, the state filed that affidavit, which, in pertinent part, affirmed that, quote, political party affiliation information as to potential grand jurors was not known or available to the grand jury commissioner or the representatives when summoning a potential pool for the 93rd grand jury. This renders the claim issue resolved. Based thereon, it's ordered affirming the prior order denying any further relief sought by defendant Giuliani in his August 30th motion. So this judge actually went to the state and said, hey, state, could you ask the jury, let's just put a bow on this and go ahead and disprove the theory. And they did. They got an affidavit and disproved it. Much like in the outcome determinative election shit, every single state officer, state election board, state governor, even the Republicans were like, we have to say that there's no outcome determinative election fraud. And Rudy Giuliani's theories without evidence are baseless. And so he did tie it up, and he did get that affidavit from the grand jury.
Yeah. And again, one more time, this isn't a bunch of people sitting around the clerk having nothing to do, having the judge say, you know what, you made this nonsense claim. I'm going to sit there and give it a little bit of time and attention to make sure that it is baseless. Go out and find these things. Go out on these grand jurors. Not that they're sitting around waiting for a call from the clerk or anybody else. They have jobs and lives on their own, but have to get contacted and say, no, this had nothing to do with it. All a leeching of the American body politic, of the American society, of the American population, of the United States of America, just sitting there like leeches, sucking off resources, time, energy to postpone the consequences that are charging down the road. It just aggravates me. But Rudy, sorry, big guy, heading to trial.
Yeah, well, this was Jack Smith's argument against immunity. And I think Sotomayor talked about it too when she discussed it in the April 25th oral argument against immunity for presidents. Because, she was like, look, our system isn't perfect, but there are plenty of checks along the way in our system that make sure that there aren't any rogue prosecutors out there. I remember, do you have any examples? I think it was Alito. Do you have any examples of a rogue prosecutor being thwarted by a grand jury? I'm like, yeah, our friend Andy McCabe. he was indicted by a rogue weaponized prosecutor, or tried to be, and the grand jury said no twice. Bill Barr even took that and shopped it to a second grand jury, and they're like, no, we don't see it.
Nope.
And so that was the argument against immunity, because Trump's argument is there'd be rogue prosecutors everywhere, always prosecuting presidents. We'll never be able to stop it. It'll never end. And Jack Smith is like, dude, we have federal grand juries, petit juries, motions to dismiss, the things that make our system take so long, the things that the reason why the wheels of justice grind so slow are all protections against rogue prosecutors. And this is an example of that we have to go out of our way to find a former grand jury guy and get an affidavit signed to disprove Rudy Giuliani's speculation that perhaps the grand jurors were brought in on political ideation grounds. And then you go through that, you get the affidavit, you put it in this, and you tell Rudy, no, I'm sorry, but none of this works, and your theory is incorrect. Those, the privilege battles that we had to go through to get Mike Pence's testimony. He was like, no, speech or debate clause. I was a legislator that day. I can't be made to testify. And so all of those layers and layers, that took a year to be able to get his handwritten notes, or Corcoran's notes, or anybody else who was claiming executive privilege. And now they'll do the same with presidential immunity. It's every single step that grinds our justice system to a halt is there to prevent what Donald Trump was arguing as reasons that there should be presidential immunity, to prevent rogue prosecutors from bringing false charges against innocent people. And to sit there and say, I don't get enough due process, whether you're Rudy Giuliani or Donald Trump, fuck you. Because our system of justice, we have to wait to get justice. Probably, in some cases, and certainly beyond the election, when we should have these things decided by then, because of your fucking privileged ass who needs all these, kinds of extra hoops that the prosecutors have to jump through to make sure that these charges stick. And they could still be overturned on appeal because of the Supreme Court. It's maddening. And for people to blame the DOJ or blame the prosecutors or blame Jack Smith or blame the Chris Mays here in Arizona, why are you taking so long? It's this shit. The reason that we shouldn't have presidential immunity, because our system, although flawed, works, but it's slow to prevent the kind of shit they're complaining about happening from happening. So anyway, sorry about my rant, but it's just, I'm tired of it. And I'm also tired of wrong people getting the blame for it in this country. The FBI, they take so long to investigate shit. It's because of shit like this. It's because of this kind of just filing after filing after filing to ensure that we aren't putting innocent people away. And these systems have to be in place for the actual innocent people. And they're being abused by these privileged criminal assholes. And that's just the way that it is. I don't know how else to say it or fix it. Because if we loosen these protections against criminal defendants, we become more tyrannical and less United States. and I'm not for that. But again, it's the abuse of these systems. Anyway, rant over.
No, it's a good rant. 100% right. 100% right.
Sorry you had to deal with that shit. I mean, I worked for the government too, and there's processes and loops and stuff like that, but I wasn't in justice. I can't imagine what it's like. And, you guys have, FBI had arguments with DOJ all the time. We're not going to do this. We are going to do this. We shouldn't search the Mar-a-Lago. We should search Mar-a-Lago. We have these internal discussions. Donald Trump wants every single disagreement with every single federal agency to try to prove that he was somehow innocent in all these cases against him. But this Friday is Trump's response in the 11th Circuit is due and this is the one, this is where, Judge Cannon dismissed the documents case against him. His response is due, and it's going to be fucking stupid. So buckle in.
Yes, indeed. Interesting. Curious if you're like, and you may cover this on Jack, about whether or not the trial of the proposed or the attempted, charged assassin of Trump down in Florida has filed to get the case reassigned, arguing that
we did cover
Cannon
that in
is
a
not
couple
partial.
days ago.
And the question of what's the government going to do? Are they going to oppose it, support it, take no position? My guess is take no position, because they're kind of in a tough spot of you haven't made the specific argument that she should be removed, but that's kind of where you're going. So
I would support it if I were them, because if they actually dismiss based on her impartiality toward Trump, that puts the documents case in a whole new light, right? That could be like, because Jack Smith hasn't asked for her to be recused, but a couple of amici have, right? Crew, and there were others, including like Olivia Troy and George Conway had filed an amicus brief to have her removed from the documents case. And if they find that she has the appearance of impartiality from, being fawned on all over by Donald Trump during this election cycle, which Routh cited in his motion to have her removed from the case, that makes it a little sticky over on the other case. And it'd be interesting to see how they rule on that. I think they'll probably reject her recusal there. That's just me. And then, of course, you'd have to argue it anew with the documents case if you were going to make that argument. But the judges in the 11th Circuit can sua sponte recuse a judge. They don't have to we don't have to wait for Jack Smith to ask for it. They can just do it on their own. They've done it before. We'll see if there's enough evidence to do that. But I support her removal from the case, because I do think there is an appearance of impartiality in favor of Donald Trump in both of those cases. And, Routh was even like, he could appoint her to the Supreme Court as a reward for putting me away for life in prison for trying to assassinate him. I think Routh has a very good argument.
Yeah, I do too. We'll see. And it's not like it's just curious whether, I'm not sure whether DOJ as a policy matter wants to take that on and support it. But, again, we'll see soon enough. But it's a good motion by the defendant.
You're right. They might be smart to be like, no comment. You choose. Yeah. All right, everybody. We'll be back next week. Obviously, for patrons, we'll be back this weekend. And interestingly, our next public episode falls a day after the election. I don't know that we'll have a winner declared, but we will actually be recording that episode on Monday. The election is Tuesday. You will hear it Wednesday. So we'll probably just wait until our bonus episode next week to discuss election results.
Well, we got another week, right? We got one more week.
Oh, it's 2 weeks. I'm sorry.
Yes,
I'm sorry.
2 weeks. So next week is our last. Next week is our last.
That's right. You said
I know, but it's like
penultimate,
the time compression is happening, right? I mean, this is like you have a calendar and whatever it is, days till vacation is over, days till you go back to school, whatever it is, it's that accelerating, like, holy cow. When did time start moving so quickly?
Yeah, I time it on releases of shows that I want to see, like season 2 of Silo comes out November 15th. We'll have
Somebody told me I should watch Silo.
Oh, it's really good. Season 2 of Severance comes out January 18th, 2 days before the inauguration. Like I that's how I think of my show releases in terms of when the election and inauguration are, and how far along the path of this election cycle will be. But anyway, thanks again, all of our new patrons and all of our existing patrons. We'll see you this weekend for the bonus, and then we'll see you next week, everybody else, for the public episode. Not election week. I was incorrect. for some reason, I just want it to be over. I think I'm moving it closer in my head so that it could be over sooner. Any final thoughts?
One side note, breaking on a Wired article. Do you remember that whole BS story about how Tim Walz had assaulted a high school student back in his coaching days or his teaching days? Guess what?
Was it Russian propaganda?
It was picked up by Jack Posobiec and Candace Owens. It turns out,
was it Russian?
Russian propaganda, 100%. Campaign to attack Walz traces back to John Dugan, former Florida cop who now lives in Moscow and runs a network of pro-Kremlin websites. So great job, everybody. Great job, Jack and MAGA Nation, picking up pure Russian propaganda that, Walz had participated in some assault way back when. All BS, all Russian disinformation.
It was either Russia or Berkman and Wohl, right? Remember when they tried to say that Robert Mueller sexually assaulted Jen Taub, and Jen Taub's like, excuse me?
Yeah. No.
Just create shit out of thin air, man.
Nonsense. And I have no doubt that sort of BS is going to just, much like our time acceleration towards the election is going on, there are going to be increasing amounts of shenanigans going on by the Russians, by the Iranians, by the Chinese, certainly by the Elons of the world. So
Elons funded by Saudi Arabia. All right, everybody, we'll be back next week. I hope you all have a great weekend. Until then, I've been Allison Gill.
And I'm Pete Strzok.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.